Gary Wall here, and this is Bridging the Week for October 26th to 30th, and today is November 2nd, 2015. Good morning. A new means for capital raising using the internet, crowdfunding, was approved last week by the Securities and Exchange Commission. Last week was a quiet week in regulatory and legal developments in the financial services industry worldwide. So if the old adage, no news is good news, has any meaning, it was a very good week. Notwithstanding, we have a few articles to cover, so let's get started. The Securities and Exchange Commission finalized rules that will permit eligible companies to raise money through internet offerings of their securities, a practice known as crowdfunding. Under the SEC's final rules, a company may raise up to $1 million in any 12-month period through crowdfunding. Companies taking advantage of the SEC's new rules will have ongoing SEC reporting and disclosure obligations, including filing an annual report with the SEC and providing it to customers. However, in general, such obligations will be far less onerous than obligations for companies that raise funds through traditional public or even private offerings. All crowdfunding transactions must occur either through an SEC-registered broker-dealer or on a new type of SEC-registered entity, a funding portal. Investors would be limited during any 12-month period to purchasing a maximum of $100,000 in securities through all crowdfunding sources and potentially much less depending on their annual income and net worth. In addition, crowdfunding purchased securities cannot be resold for 1 year. The SEC's new crowdfunding rules will be effective 180 days after they are published in the Federal Register, although forms enabling funding portals to register with the SEC will be effective January 29th next year. The Goldman Sachs Group and Goldman Sachs & Co. agreed to pay a fine of $50 million to the New York State Department of Financial Services for allegedly failing to institute and maintain procedures to preclude the firm's possession of the department's confidential supervisory information. According to an agreed order, Goldman Sachs hired an unnamed individual who previously was a bank examiner at the Federal Reserve Bank of New York. Shortly after commencing his employment, the individual forwarded guidance from the New York Fed to his Goldman Sachs supervisor, saying he was prohibited from 1 year from directly working, quote, on matters for or on behalf of, end of quote, an unnamed regulated entity that had previously served as the principal contact for while at the New York Fed, said the order. Notwithstanding, according to the order, the individual was placed on matters for the regulated entity from the outset of his Goldman Sachs employment. The order alleged that the individual also, quote, wrongfully obtained confidential information, end of quote, from the New York Fed, including approximately 35 documents during his Goldman Sachs employment, including at least 9 documents that the New York State Department of Financial Services claimed was, quote, confidential supervisory information, end of quote, under New York law. According to the order, the individual shared some confidential information regarding the regulated entity with other Goldman Sachs employees, including his supervisor. Goldman Sachs terminated both the individual and his supervisor. As part of its settlement, Goldman Sachs agreed to enhance its relevant policies and procedures and not to accept for 3 years new consulting engagements that require the New York State Department of Financial Services to disclose confidential information under New York law. The Securities and Exchange Commission approved amended rules by the Financial Industry Regulatory Authority to require quicker reporting of so-called trace-eligible securities by firms required to report transactions. Currently, under TRACE, FINRA's Trade Reporting and Compliance Engine, broker-dealers must report transactions in certain fixed-income securities within certain time frames, typically 15 minutes. This information is then generally made available to the public. Under the new FINRA rules, approved by the SEC, firms must report transactions in trace-eligible securities subject to public disclosure, quote, as soon as practicable, end of quote. FINRA's new rules are effective November 30th, 2015. And finally, 5 more broker-dealers agreed to pay back more than $18 million to retirement accounts and charities for overcharging them mutual fund sales charges following disciplinary actions filed by the Financial Industry Regulatory Authority. The firms were Edward D. Jones & Company, Stifel Nicholas & Company, Janney Montgomery Scott, AXA Advisors, and Stevens Inc. Earlier this year, FINRA filed a similar action and affected $30 million in restitution for similar conduct by 5 other broker-dealers. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWall. Have a great week, and as always, ciao!